Alex here with part 24 of the My Docket series on on Corazon real estate. Um, yeah, I fell behind again. I'm going to do 6 of these in a row. This time I'm not going to have a costume to wear. Halloween's over now. But yeah, I've been so backed up with everything else that I keep falling behind on this channel. I have seen a few people post in the comments that they were successful on a particular issue in court representing themselves. For those of you who don't know, you can send emails to admin@theproperperson.com, and that's how I can set up viewers' victory interviews. Anyway, I'm going to go ahead and knock 6 of these videos out. And starting with this first one, which is a motion for judgment on the pleadings. Mindset was probably annoyed and angry. The biggest reason being that to me, it seemed clear that this case could not be defeated at the early case termination phase. Please watch my video on the topic early case termination. And so I felt like I was going to have to do extra work that I shouldn't have to do. I was expecting summary judgment motions, but this was just annoying. I still had to deal with it, and I mean, we can talk about it as we go through the next 6 videos. So I did want to mention that it was frustrating / annoying to get something like this right after I had the decision of the court reversed. But it also, at least in some sense, I can understand where it's coming from, and I'll be able to go into the details shortly when we go into what the attorney for Corazon Real Estate has filed. Here we have their motion for judgment on the pleadings. So my understanding is that it's very similar to a motion to dismiss for failure to state a claim. Motion to dismiss for failure to state a claim is actually, I'm not going to talk about that in detail because I have a video literally called Motion to Dismiss for Failure to State a Claim. So please take a look at that video. But it's very similar to that. The only thing is that my understanding is that with a motion to dismiss for failure to state a claim, no response has been filed in the case. Whereas a motion for judgment on the pleadings is something that's attempted after the pleadings have been filed. So complaint and answer. Since the complaint and answer has been filed, they can do this. I wonder if, I wonder why they didn't just file the motion to dismiss. They filed their answer, and maybe they used their answer in some way. It does seem odd. I rarely hear about these being filed, and that's probably because the defense can file a motion to dismiss without having filed their answer. You know what? This is really weird. It is really weird for a motion for judgment on the pleadings to be filed by the defendant at all. Because it kind of makes more sense to me that a defendant files an answer and then the plaintiff uses their answer in the motion for judgment on the pleadings. For the defense to have filed this is super weird. It's not. It makes me feel like they didn't realize they could do this. So they filed their answer and then they realized, oh, wait a minute. We can actually do this motion to dismiss for failure to state a claim, and we just already filed an answer, so we're gonna just do it anyway under motion for judgment on the pleadings. Okay. You know what, guys? I also have another video on the topic motion for judgment on the pleadings, so feel free to watch those 2 videos, compare and contrast, and hopefully it kind of connects in your heads as well as to why this is really, really weird coming from the defense. But okay, we'll go into it. Contract tort action arises out of a former landlord-tenant relationship, dissatisfied with how the premises were maintained, notice of termination and move out, initiated the lawsuit, wrongful eviction. Okay. You know, in hindsight, I would have done much more research on wrongful eviction. I don't really feel like I did much. And back then, of course, I mean, you really don't know anything. Even now, knowing as much as an attorney takes years and years of constant litigation, which is, very difficult for a non-attorney to do since it's not your job. Procedural history. What do we have? Tenant at the residence, various maintenance issues, Let's see. Yeah, so this is pretty consistent. Was not happy with how they maintained. So I invoked a law, and then they said, well, it's nice that you're invoking the law to not pay rent. We're just going to evict you for non payment of rent. I talk about this in the video, summary eviction for non payment of rent, how landlords use this to basically flout all of the other legal protections that tenants have. There are legal protections in place that say tenants don't have to pay rent if certain things are occurring. In reality, though, what happens when you try and use those rights 99% of the time is that the landlord just files an eviction for non-payment of rent. Most tenants then get afraid, get scared, and then they give up or they quit, or stuff like that happens. I talk about it in detail in that video. Take a look at that video. So they're going to use written notice of intent to terminate. Okay, yeah, this rent had to be paid to avoid the summary eviction, and then I filed a move out. One thing I want to mention, because I was worried before having filed this, if they do coerce you into moving out, do you then lose the ability to bring a wrongful eviction? Now, I consulted with attorneys and they said no. If you are coerced into moving out, you can still use the wrongful eviction. But like I said, guys, I don't recall looking into very much case law on this. Maybe I'll surprise myself and I'll see it. Who knows? But just off the back of my mind, I don't remember that being something that I looked at very deeply. Temporary restraining order. And I think I talked about why this does make sense in the video when this comes up in my Docket series, so I'll just skip over it. I do talk about the court's denial of the temporary restraining order, and I do, in hindsight, agree that that ruling makes sense. Motion to dismiss was filed by a non-attorney on behalf of Corazon Real Estate. I filed a notice of appeal. The Supreme Court reversed the decision, indicating that I was right. He's not allowed to appear in proper person on behalf of his corporation. Everything was stricken. I filed an amended complaint. So wrongful eviction was raised, retaliatory eviction, conversion for withholding the security deposit. So then we've got the $509 in actual, $2,500 for retaliatory eviction, and unspecified punitive damages, which you're allowed to do. Corazon moves for dismissal of plaintiff's amended complaint under 12C. Standard of judgment under 12C. After the pleadings are closed, you can do this. That's correct. Submission of the motion cannot delay trial, which is good. It's true. It allows you to dispose of cases. Yeah, I talk about this in the video early case termination. That's true. All of the material allegations of fact are admitted in the pleadings and only questions of law remain. Here you can see what I was talking about earlier. Motion for judgment on the pleadings is appropriate when all material allegations of fact are admitted. You can see that it is super odd for the defense to do this because this is a plaintiff's mechanism. It was meant to be that way. It doesn't really matter. I mean, it is so weird. I mean, I wish an attorney would watch this and pipe in with a comment or something. A judgment on the pleadings under 12C is granted when the plaintiff would not be entitled. See, again, they keep talking about the plaintiff. It is awkward for a defendant to use this. Defendant nevertheless finds himself the target of the instant lawsuit. Plaintiff's claims are premised on Chapter 118A. Plaintiff's amended complaint based primarily upon Chapter 118A. Plaintiff alleges the defendant wrongfully evicted. So I think what they're going to say here is that because the amount was paid to avoid the eviction did not occur. Well, they're still talking about the reparations of the toilet and stuff. Plaintiff was not evicted from the dwelling unit. So yeah, so they're basically, okay, this is an argument that I expected. They're saying since I was coerced into moving out, that doesn't count as an eviction. This is one of the things that I talk to attorneys about. I wonder if this is something that I deal with on opposition. Makes me interested to see. That's going to be in the next video. So I don't know why they 7649 for alleged failure to make dwelling unit habitable for a period of 23 days. Maybe I'm talking about the fact that payment was coerced by the court in the summary eviction court, and therefore this money, maybe the $76 is the balance of, I don't know. We'll see. Best efforts to remedy the problem. See, I was worried about this best efforts line because this could be read in so many different ways. I mean, what are best efforts really? And this is something that's very frustrating, I think, probably for a lot of non attorneys, because a landlord is going to usually be able to afford an attorney, and an attorney is going to be able to exploit the discretionary power of the court to rule in their favor. If you want to learn more about this, watch my video on the topic discretion. My big beef here isn't even with the lawyers or the judges, it's with the legislature. They should have defined what this means or even remove it. Because when you think about it, best efforts or not, if somebody's living in a unit that's not what they paid for, why are they paying the rent for it? Like you're gonna live in a unit because you expect shelter, toilet, hot water, cold water, etc., etc. When these things aren't working, whether it's the landlord's fault or not, you're not getting what you paid for. So by adding best efforts, they can actually create a situation where a tenant can end up with substandard expectations of what they thought they were going to get into, with the landlord saying, hey, well, I'm sorry that you're not getting what you paid for, but since we're giving you our best efforts, there's nothing you can do about it. But that's a problem with to me, this is legislative incompetence, not judicial. I mean, attorneys are going to use whatever weapons are at their disposal. So if the legislature creates loopholes like this, you can't be surprised that the attorneys are going to use them. So they're saying that allegations are not sufficient. I mean, if I had more time, I would look over the complaint again and point out where they are. But I can recall calling them out for these types of issues. If I don't use the exact word failure to make the unit habitable, that's not going to be something that actually is a basis to dismiss. You can still, what they call, interpose an allegation. Plaintiff admits issues associated with the toilet were repaired, undisputed. The defendant made attempts. So yeah, they're using they're using the best efforts. You can see here how they use this as a shield, basically to justify that the unit wasn't working. But since they were trying, without a definition to what this means, it creates a huge, unknown fogginess in the case. Jurisdictional grounds. So they're trying to argue that without punitive damages, there is no jurisdiction, which is true. The case requires punitive damages to stay in the district court. It's absolutely true. Common law claim of conversion. I think that this is probably true. Because if you have a security deposit, that's going to be under a contract. And if you're not getting paid back the security deposit, that's going to be under contract principles. So this is probably true that conversion claim has to be dismissed. Now, I would agree with that in hindsight. All remedies arriving, remedy available. Yeah. Okay, so you could say the contract or you can use the statute. So, I mean, this could be a basis to amend the complaint to include this request instead of pleading conversion, but it doesn't matter. I mean, this case is long closed. But this is true. I agree with the attorney here. Yeah, if there is a legal claim or even a contractual basis, then you don't need this common law claim for conversion. Okay, all in all, a decent motion. I really do think that this makes sense, even though I don't agree on a personal level with the best efforts language. I talk about this in the video, bad laws. The legislature will sometimes enact a bad law, and there's nothing you can do to get around it. You just have to deal with the mistake. There's no way that I'm going to say that was a good idea. The best efforts thing, without a definition, a clear definition of what best efforts are, all it's going to do is create situations where landlords can claim that they tried their hardest. And I mean, to me, that's subjective. The judge's opinion is going to decide what best efforts are, or if you get a jury, then the jury, which actually wouldn't be so bad. Definitely wouldn't be as bad for a jury to decide that. In any event, that exploitation of the best efforts language in the statute is what I would have done if I was the lawyer. So she was doing what I would have done if I was her to defend the landlord. And then the dismissal of conversion because it's not the appropriate claim, I would also agree with. So all in all, I think this attorney did good, even though she's not on my side. It makes sense what she's doing. 30-day notice of intent to vacate, and then the ex parte motion for TRO. So these are already filed in the case, guys. My standard policy in the My Docket series is to not go over documents a second time. If you would like to, keep in mind you can always go down into the description below, click on the links, download these for yourself, or download this document for yourself, take a look. If you think I missed something, just let me know and I'll go ahead and address it. But if you've been watching this series from the beginning, then you would have seen me go over these two documents already. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. This, I believe, is a free filing because it's a motion to dismiss. So or motion for judgment on the pleadings. So I imagine that's going to be $0 in costs for them. I didn't have an attorney, so I incurred $0 in attorney fees. They have obviously gotten an attorney. Motions are, they have to do their legal research, type it up, consult with their counsel or consult with their client. I would say I struggle with saying less than 1 hour. I feel like 2 hours. Let's just say 2 hours. I imagine they probably billed them for 2 hours. At the rate of $250 an hour, that's going to come to $500 in attorney fees for Corazon Real Estate. As for my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.